Okay, the recording has been started.
Great. Good evening. We're on the record in the matter of encroachment permit application number L-97-S-1210. The applicant is Bonner County Parks and Waterways, who I'll just simply refer to as Bonner County. My name is Chris Bromley. I'm a private attorney serving today as the hearing coordinator in this proceeding. Today is Monday, January 10th, 2022. Time is shortly after 6 p.m. Pacific time. The public hearing today is being conducted in person and via Zoom. So before I open the hearing for comment, I would like to ask Chris Gozo with the Department of Lands to give a brief tutorial and overview on how to use Zoom. Go ahead,
All
Chris.
Thank you, Mr. Hearing Coordinator. Let me go ahead and share an image here. So for those that are connected via the Zoom interface from a PC, a couple of things we'd like to touch on here. You'll notice in the bottom bar of your Zoom interface, to the left, there's your mute button. That's how you can mute and unmute your microphone. We do ask that everybody stay muted during the hearing unless you're called upon to speak. That way it'll reduce background noise for the rest of the group. And then there is also a chat button in the bar as well, in case you need to type a message to the group or in case we request an email address or other pertinent information, you can chat to myself or the hearing coordinator there, or to everyone. When you click the chat button, you'll see a window come up to the right. That's your chat window. And then you'll see the to field where you can drop down and select who the message is going to. So that's just some basic Zoom functionality. For those that are calling in on a phone, so not from a computer, we just ask that you mute the device if possible. If it's a cell phone, mute it until it's your turn to speak, and then you can unmute when you've been called upon. And that's it, just a brief Zoom introduction. So I'll go ahead and stop sharing.
Thanks, Chris. That was probably more important maybe 18 months ago or even a year ago than it is in the last 6 months, as I'm sure everyone has become quite familiar with Zoom. But still, it's worth just remembering, particularly the mute function. So this evening, I'm facilitating a public hearing involving Bonner County's encroachment application. My responsibility is to consider the application and the written record, take comment, and determine if the application meets Idaho's statutory, regulatory, and case law standards for approval. I'm then tasked by the Director of the Department of Lands with issuing a preliminary order, which will be reviewed by the Director, who will then issue a final order no more than 30 days after the conclusion of the hearing. So before we begin, and as I mentioned off the record, I would just like to establish the order in which I take comment. First, I'll take comment and testimony from the applicant, Bonner County, to provide an overview of the application and offer any comments it wishes to make. Second, I will provide an opportunity for governmental agencies other than the Department of Lands, if they wish to provide comment. And let me ask on that point, Mr. Amer, do you know whether or not there are any agencies who are going to be providing comment tonight?
No, sir, I do not believe so, just Bonner County.
Okay, thank you. I didn't see any written comments from any of them, but always want to ask. So then, since we don't have any other governmental agencies, we'll go straight to public comment. And I think the best way to do that is first, let's hear from Mr. Magnuson. And if we have others who wish to make comment after Mr. Magnuson, either in favor or against the application, let's hear from them. And just so everybody knows, I provide equal weight to written comments as well as oral comments. So if you submitted a written comment, I have read it. I've in the process of considering it. If you also wish to provide a spoken comment, that's fine as well, but please know that I provide equal weight. After all of that, then I will ask Mr. Amer with the Department of Lands to provide any comments he wishes to make, and I've seen his written comment as well. And then finally, I'll take comment again from Bonner County as the applicant in reply to make any closing remarks. So because this is a public hearing in which I'm taking comment, there will be no cross-examining or questioning by anyone present of anyone else. But that being said, please know I may have questions, so don't be surprised if I ask a question. And as Mr. Gozo indicated, this is being recorded and may ultimately need to be transcribed for a record if it goes up into a court process. So just to make sure that we have a clear record, and yeahs, nodding of heads, please make everything verbal so that if it has to be transcribed, the reporter can accurately transcribe and write down your comments as you said them. Lastly, please remember to be respectful and courteous of others when they are speaking. Please remember to silence your cell phones and muting yourself on Zoom while others are speaking. Please remember to be patient if any technical difficulties arise. We're not expecting any. That being said, with technology, you never quite know. If for some reason something goes wrong, we will be in touch with everybody. And with that, I will open the hearing and ask Bonner County to please describe the application and provide any comments it wishes to make.
Mr. Hearing Officer, this is Angela Kaufman, Deputy Attorney General for the state. Before we get started on the hearing, I need to let you know, as part of my obligations as an officer of the tribunal, that we learned, we being IDL and myself shortly before the hearing, that while notice of the application itself was published in the local newspaper of record, which was the Bonner County Daily Bee, and while notice of your appointment and notice of the hearing was sent to the applicant, the objectors, their respective counsel, notice of the hearing was not published in the local newspaper of record, again, which was the Bonner County Daily Bee. That was the reason for Mr. Amer and I rushing in at the last moment to the hearing, was we were just verifying that information. So, I recognize that there are already a lot of comments in the record, as you have seen, including coming in today. There are people on the phone, people who have prepared, but obviously out of my duty of candor towards the tribunal and fairness to everyone, I wanted to make sure that the applicant, the objectors, and most of all yourself were aware that the notice of hearing was not published in the local newspaper of record.
Let's go off the record.
And the recording has been resumed.
Okay, thanks, Chris. We were just off the record talking through the question that Ms. Kaufman raised about notice. Mr. Amer, could you provide an update on where we are with notice of hearing being published and having evidence of that?
Yes, Mr. Hearing Officer. Ryan Zanhusen up in the Priest Lake office, the resource specialist, on Tuesday, December 21st, 2021, emailed Mary Moore, who works with the CDA Press. The CDA Press also manages the Bonner County Daily Bee. And he emailed her with a copy of the clipping, and she responded back on Tuesday, November 22nd at 2 p.m. saying that it had been received. We did not receive the typical clipping we get from them, but Ryan was texting me and letting me know that there's a good chance that the front desk person of that office might have gotten that clipping. Usually the front desk staff is the one that pays those bills to the newspapers, and they're the ones that handle those. And so there's a chance that there's a good chance that she had it and just didn't forward to Ryan yet. But I do have, like I said, I do have an email from Ryan on the 21st, emailing them the notice of the hearing, and we have confirmation that they received that email.
Okay, and what I would then propose is if you can please then track down the clipping that we usually see in the record and supplement the record with that clipping and with the email that you just described. And I realize that's not going to happen today, but we can do that, tomorrow. I think that would be just fine. Any objection to that idea from anyone?
Like it looks like it was published.
Okay, hearing none. To me, it sounds like, the notice issue, if there is a notice issue, and people want to address it.
Mr. Hearing Officer, John Magnuson just gave me a cell phone. He was able to find the posting. Looks like it was posted on December 30th and January 6th. And definitely on December 30th, there's a posting about this mentioning the hearing being on the 10th at 6 p.m. and it gives the link. And John, how did you find this?
I Google searched the Coeur d'Alene Press Bonner County Daily legal section.
So John found the clipping through just doing a little Google searching for it. So we'll get you that clipping, but I think this is further proof that it had been advertised.
Thank you, Mr. Magnuson. Appreciate that. Ms. Kaufman, you raised it. I appreciate you raising it. Given what you're hearing now, do you have an opinion?
I am fine with proceeding. I apologize for the hiccup in the proceeding. I'm glad that it all worked out. So I would say let's get to the heart of this.
Okay, well, I appreciate Ms. Kaufman, you raising it. It's always better safe than sorry. These notice things are tricky, and I'm glad we got it right. So thank you very much.
You're welcome. Thank you.
So with that, Mr. Cardona, will you be presenting for Bonner County?
Yes, sir. I will be presenting for Bonner County, and we do have Commissioner Jeff Connolly and Pete Hughes, Parks and Recreation Director, here present with us today. Bonner County has reviewed the analysis and recommendation of the Idaho Department of Lands and agrees with it. The permit should be provided for all of the benefits that have been identified. There were a couple of questions there under IDL's conclusions. So just so you know, any conditions that are imposed with the intent of maintaining the public expectations for the site are very likely to be to the benefit of the whole community. The county wishes to work with the community to ensure that this public access, this historical public access, remains open. The one thing we sent as exhibit for the hearing was the memorandum order and decision on the motions for summary judgment that IDL itself refers to in their filing. I believe it has a very good history of the property at issue, that the improvements are grandfathered in. With that said, we do want to ensure that the operations do not unnecessarily inconvenience the local community while providing access to this state resource that benefits everybody in and outside of the county. IDL mentioned that it required additional information about the water hydrant. My understanding is that the hydrant is located in the state lands. And what it is essentially a pre-installed filtration system so that the firefighters can connect into it and provide assistance without having to bring their own filtration systems. As far as the
Mr. Cardona, on that point, I think I accidentally hit someone else's unmute button. Do you know when the water hydrant was installed?
over 20 years ago. We didn't install it ourselves. We did some checking with the fire district, and it appears to be over 20 years ago, Your Honor.
Was it prior to 1975?
Oh, no. We do not know the answer to that.
I thought I heard an oh no, it was not, or you don't know, or.
We don't know.
We don't have the answer to that.
Okay. And is it only used for fire, or is it used for other reasons?
Oh. My understanding is that it's just available for the fire department to fight emergencies. Pete, is that your understanding also?
Yes, sir.
So it is our understanding.
It's to draw water in case of, with the fire trucks. I don't know that it's ever been utilized. The residents could probably answer that better than we could.
Okay, well, thank you.
Then when we go to any signages that will be placed, we can represent to the department that we have a right of way that is made out of the road that leads to the place where the encroachment will start. So we have plenty of room for any signage that may be necessary. The point of the signage will be to ensure that the public knows how to use the boat ramp, which we believe will be useful for the community in reducing the adverse impacts of having public access. Everything else, Your Honor, I believe is well detailed in our application. I have the decision makers here, so we can give you answers to any questions you may have. County wants to be a good neighbor and continue to provide the recreational access. Thank you.
Okay, thank you. So my understanding then, Mr. Amer, there are no other governmental agencies involved in this, is that correct?
Correct.
Okay, let me just put it out to the audience and just double check that we don't have somebody, any governmental attorneys or representatives of agencies on the line who wish to provide comment. Okay, hearing none. Mr. Magnuson, let's turn to you, as I said, and happy to hear your comments and have your exhibits as well.
Thank you, Mr. Bromley. John Magnuson for the Outlet Bay Property Owners Association. Mr. Hearing Officer, again, you indicated you have the exhibits close by, so if I refer to them, will they be accessible to you?
Yes, I have them right here, Mr. Magnuson.
Okay, well, thank you. I'd like to note that like a lot of things that find their way to the Department of Land's hearing, we have another historical vagary that seems to have only been the product of a place like North Idaho. This requested encroachment, I think quite likely would not be permitted today under today's rules if we were starting from ground zero. It's a historical anomaly. What I set forth in the facts to you, that simple recitation of facts, is obviously the parties have been in disagreement on many aspects of the boat launch for time immemorial. But the points that are not disputed, and it's important to note this when we get to the conditions on the permit should you issue it, the points that aren't disputed is this community was platted years ago with a right-of-way essentially through the middle of it, And by private monies, the private resort owner in approximately 62 put in this boat launch, regulated the boat launch, and then at various points in time, Bonner County said, yes, you, the association, own the boat launch, you can control it. At other times, Bonner County said, no, you don't own the boat launch. And the issue boiled down to, as you probably have divined from the decision, who owned the littoral rights that were associated with the terminus of the street, platted and dedicated at its intersection with the ordinary high water mark. And the court held that Bonner County, in fact, has those littoral rights, but it's helpful to reflect upon those factors because nobody would likely permit the boat launch for public use today in that manner because it was put in by the private developer who owned the development at the time under the belief he had it, but it doesn't comply with the requisite presumptions on adverse effects because of setbacks. And in this instance, there's no question that there's no 25-foot buffer to the adjacent property of the association on either side. That is a requirement of IDAPA 20.03.04.020, simply a presumption that can be rebutted, but there's no buffer. Idaho Code Section 58-1306 says when we look at commercial navigational encroachments like this, the factor that should be given the most weight is the adverse impact upon adjacent littoral owners. So if we looked at it today, we have another added wrinkle. It's been noted that the boat launch is grandfathered because it certainly predated adoption of the Lake Protection Act. But I note that under Idaho Code Section 58-1312, if a pre-existing grandfathered encroachment is replaced, then it must satisfy the contemporary permit requirements. And that's not unlike somebody on the lake who has a 1,200 square foot dock in excess of the 700 square feet allowed. And then they go replace the entire thing, it has to be 700 square feet. So in this instance, if we had this application coming in today with no dispute that Bonner County replaced the boat launch, tore out the boat launch without a permit, replaced it with a special use permit, but the actions are not consistent with what is treating it purely as grandfathered. It must come through the door today under current standards, which is another reason why the setback is important, because there is no setback. And I'd also like to note on the concrete wall and the hydrant, which the county seeks to permit through this process. If you look at the application, the next to the last page of the encroachment application, you can see a exhibit map prepared for Bonner County by Glahey. And I don't know if you have that in front of you, Mr. Hearing Officer.
I've got it right here.
If you look towards the east side where the boat launch is located, you'll see north of the boat launch is where this concrete pier bulkhead is located. The concrete pier is outside of the littoral rights of Bonner County as determined by the court. And if you also look at the exhibits that I have offered and several at the back, I would note exhibit M8 and M9. Simply, you can look at them later. You can see the fact that the concrete bulkhead, concrete wall is located outside of the littoral rights that are associated with the terminus of Outlet Bay Road at the ordinary high water mark as determined by the court and confirmed by the submissions of Bonner County. So regardless of the application for the boat launch, that wall, you can't, I would respectfully submit, you can't permit lawfully somebody else's encroachment. And the same would hold true with respect to the hydrant. Now, nobody, I certainly, and you'll hear from some of the association members, or they've made their comments and may be heard today. I don't think anybody has a problem with the hydrant and the ability of the local fire district to utilize that as a resource. But from a technical and legal standpoint, that hydrant appears to be authorized by littoral rights that are not the littoral rights of the county. So, you know, I say all that and it sounds good, at least it does to me, but the practical fact is there is a boat launch there. And do I think it very likely that the hearing officer is going to deny a public agency an application to maintain a boat launch regardless of the no setback? I don't think that's likely, but I think that appropriate conditions should be made. And I was heartened to hear that Bonner County was conscious of those limitations or restrictions potentially. And I was equally heartened to hear that from the Department of Lands, because I believe that for a commercial navigational encroachment such as this, particularly with the setback issues and the historical genesis and the fact that it must comply, I believe, with today's standards, that you have the authority to put reasonable conditions on such a permit. And I would suggest that those reasonable conditions would be sixfold. Number one, I think the reasonable conditions need to be in terms of time of use. You have a launch that is in the middle of a public neighborhood with no setbacks, and it should be consistent with historical use. It should be a daylight only use. Number two, it should have a gate so as to ensure that the daylight only use is observed. And one of the things that Bonner County notes that is problematic is that they say, best management practices, that they will make routine inspections throughout the year. If nobody is there to inspect it on a daily basis, and I don't know that that's feasible for the county, then certainly some mitigatory action in the nature of a gate should be put in so that we don't have the disturbance of the peaceful and quiet enjoyment of the neighborhood. Number three, no parking on the street. That seems self-evident. You shouldn't be parking on one of the homeowners' yards. Number four, because of the spacing and limitations of the boat launch, it's really a back end only, and there's no turnaround at the end, and that should continue. And number five, I think the signage is important, and it's important in terms of where it goes and what it says. And I think that the language of the signage, should you grant the permit, should be, subject to the approval of the Department of Lands and homeowners, so that there's an accurate statement of what the rights are in a manner consistent with your permit, should you issue it. And lastly, the permit should exclude the concrete bulkhead and the hydrant. So for those reasons, the association objects to the permit, asks that it be limited, and I would stand for any questions, sir, if you have any.
So Mr. Magnuson, let's walk through your exhibits just so I'm clear what it is you want me to see.
Certainly, I can start. Go ahead.
No, I just want to let you know, I really appreciate photos. For me, they're very helpful. So let's look at Exhibit A, which is an aerial. If you could just explain to me what I'm looking for there.
Exhibit A would be on the declaration of Mr. Dittman.
That's correct.
Yes.
Yeah, I'm just going down through the document.
And I do think that's probably one of the most salient exhibits. This is an exhibit that was prepared by Mr. Dittman, a licensed engineer, and submitted in the underlying litigation for purposes of acquainting the court with the location of the improvements and what one can see. So there's an aerial view looking at Outlet Bay Road as it goes down to the ordinary high water mark. So which would, if you look at the plat, this would be going west to east and going down to the water. You will see towards the intersection of the water, you can see how the road, the width goes east to west and is consistent with the boat launch. And then north of that, you'll see the concrete wall connected with the sidewalk that is part of the improvements associated with the Outlet Bay improvements. You'll also see a box that says new concrete. And the new concrete was a product of, the genesis of yet another one of these disputes, but Bonner County there's no question Bonner County had the right of way. The question was whether they had the boat launch. So Bonner County went out and tore up the boat launch above the ordinary high water mark, and then proceeded where you see the ordinary high water mark crossing the boat launch to then tear out below the ordinary high water mark. And that, as shown on this aerial, was observed to be new concrete on the date of the preparation of the image, which is dated in his declaration. It was about in May of 2021, plus or minus. So you can see where the new concrete was poured above and below. But that's an orientation. The house on the top is a house of a member of the association. The house below is a house of a member of the association. And then you can see the truck parked right under the label Outlet Bay Road, which kind of shows you the width of the right of way. So there isn't a turnaround.
Okay, the concrete, so I'm oriented nicely here with the boat launch, the boat ramp. The concrete pier, where is it again exactly?
It lies north of and parallel to the edge of the boat launch. So if you go to the box that says new concrete and go just above that, you'll see it extending to the east.
Okay, and is it? I'm looking at the dashed line, which is that referring to the ordinary high water mark?
It is. That was located. Of course, it was pre-summer pool, so that was a demarcation of the location of the ordinary high water mark, and that was done for purposes of showing that there were improvements made by the county on the boat launch below the ordinary high water mark, but it was extended further north and south for points of reference.
Okay, and then the concrete pier is both above and below the ordinary high water mark, is that correct?
That is correct.
And then the hydrant, where is it located? Is it in this photo?
I cannot locate the hydrant. I don't know where the hydrant is on this photo.
Okay,
One of the members of the association, presumably, who will offer a comment, could assist you in that, I would think, but I can't, sir.
okay, that would be helpful. I'm interested in just, I like being oriented, and this one's very helpful for me. So thank you very much, Mr. Magnuson. I'm gonna scroll down then to what shows as Exhibit M6. And if you can just describe this photo for me.
And M6 would be if you took Exhibit A to Mr. Dittman's declaration and just kind of went up higher and higher. This takes us out to, this is looking east down Outlet Bay Road towards the boat launch. So at the end of that photograph, towards the water, you see the house with the green roof. It's the last house left of the roadway when you look towards the water. Do you see that, sir?
I do, thank you.
And that's the same house with the green roof that you see on Mr. Dittman's aerial exhibit as being right by the boat launch. So this is what someone who is going to use the boat launch as a member of the public would see if they looked down Outlet Bay Road heading towards the boat launch, with the private yards on the left and the private yards on the right and the road.
Okay, thank you. So then the next one I'm looking at is M7.
And M7 is oriented, now you're down on the boat launch looking backwards the other way, looking west. On your right is the right portion of the photograph, right lower corner is the concrete wall that's partially above and partially below the ordinary high water mark. You'll see the road width, and that is the boat launch after it had been taken out by Bonner County and before completion.
And I feel like I see I don't know whether this is just what I'm seeing, but if you could help me, there's an overturned boat. just to the left of the launch, and is this a pipe that is between the launch and the boat? I see what looks like a 90-degree elbow on something that maybe is a pipe, and is this the water hydrant?
You know, it seems perhaps that could be a reasonable inference, but I couldn't tell you that. And again, somebody from, I think Mr. McEachern's out there tonight, and he would be conversant because he took these photographs and he would be able to tell you that.
Your
Okay.
Honor, the county has conducted a site visit, actually several of them, and we can confirm that is the hydrant.
Okay, thank you, Mr. Cardona. And then we'll, like I said earlier, we'll ask for other comment and from the public, and some of whom I suppose are Mr. Magnus's clients, and I guess we'll get down to the bottom of that. It's very helpful for me to be oriented with all of these things. So thank you for your patience walking through these, Mr. Magnuson. I'm looking now at M8.
And that would be, you can see, if you compare that with M7, you see the two cones in about the middle right side of the page on M7. Those are the same two cones in the foreground at M8, looking back towards the launch. So looking again to the east, down to the area where it had been disturbed by Bonner County prior to re-pouring of concrete and grading. And on the left of the M8 photograph, you'll see the concrete that is referred to, that is north of the right-of-way and then extends over with the walkway to the association's property.
Okay, so this, I see what appears to be two stakes, maybe with a sign there by a curb.
Yes,
Just to the water side, which I think you're saying is east. Is that then the concrete wall?
the concrete wall is the piece in between that sign and the edge of the disturbed boat launch.
Okay,
The silt fences are down at the base of the waterward section of the boat launch proper.
okay, right. Okay, so there's a little triangular piece that then would blend in with the silt fencing, and that's the concrete wall.
Yes,
Okay, great. That, again, thank you for orienting me. Scrolling then to M9.
and M9 is if, in that prior picture, if you went down and stood in that area left of the silt fence in M8, and then looked back up to the west at the boat launch. And obviously in M9, the concrete has been repoured, so this was a subsequent photograph.
And then there's the, what appears to be the water hydrant that we'll get confirmation on. And I know we've heard from Mr. Cardona, that's what it is, but we'll get confirmation on the water hydrant again. Anything else? I think I interrupted you, Mr. Magnuson.
No, I was just saying that the perspective is offered is just to show different perspectives, different points in time, but you're able to determine when they are, based upon the condition of the boat launch itself. So this is obviously post removal and after restoration had been done.
Okay, well, scroll down now to M10.
And M10 would be the same picture as M9 if you rotated, if the photographer rotated himself to the left, which would be east. So this photograph is looking south. It's looking southerly with just a slight bend to the west. Does that make sense?
Yeah, it does. Yes, thank you. I think those are all the photos. Have I missed any photos, Mr. Magnuson, that we haven't talked about?
I do not believe so.
Okay. I don't have any other questions. Thank you, Mr. Magnuson.
Thank you, sir.
Mr. Hearing Coordinator, if I can jump in real quick, there's an individual that just joined called Greg's iPad, and we're picking up some background noise. So if you'd be so kind as to mute your device until it's your turn to speak. Thank you.
All right. So let's do this. I think there are few enough of us here that we can just ask people to start speaking. If we need to create a list to go through, we can do that. But I think there are few enough of us here, and everybody's been very respectful so far. So let's open it up to those who would like to speak about the application. Any comments from anyone who'd like to add anything about the application?
I don't know if you can hear me or not. My name is Alan McKeecher, and I'm actually a charter member of the Homeowners Association. And are you able to hear me okay before I move forward?
Yes, Alan, would you please spell your last name so that I make sure that it's correct?
Of course, Mr. Hearing Officer, it's MC, capital EACHERN. First name's Alan. I've also submitted comments, so you might have reviewed those.
Thank you, Mr. McEachern.
You bet. So the first thing I wanted to state was just to substantiate what you suggested or thought might be the hydrant. You noticed the pipe between the, right after that turned over boat. And I just wanted to substantiate, that is, I just actually reviewed a picture of that. I think it's probably the same picture, but that is in fact the hydrant.
Thank you very much. That's very helpful.
But at any rate, just to let you know, I have actually been a charter member of the association. I've been associated with this association since its inception. In fact, I worked with the developer in 1993 on the project documents to develop the association. I was the first association president. And at the time that we bought the property, there was absolutely no misunderstanding. I mean, up until just recently, I would say, even with the core hearing, I would say that the association proceeded under the understanding that they had complete control, ownership, operational control, and maintenance of the boat ramp until recently. And we've operated in that fashion. We've allowed the public and the general public or the people in the vicinity to use it unrestricted. And I listened intently to Mr. Magnuson's list of restrictions that he would recommend. I would just say I'm on board with those. But the concern that I have, my opinion would be the boat ramp should be absolutely closed and not used. But if that's not going to be the case, then there certainly should be some restrictions on it. And the question then becomes, well, why do you feel so strongly? And I would say the reason is because of 27 years of observations. First, Mr. Hearing Officer, the fact is this: the only way that you can successfully launch a boat is to literally drive backwards 350 feet to the water. And I would suggest that that's inherently dangerous. It's almost impossible, unless you're a truck driver with good skills, to do that without trespassing on OBOA property. And as I said in my statement, it is not uncommon, and I'm sure other association members would support this, it is completely not uncommon for landscaping, flower pots, fences, anything that is on both sides of the roadway to be knocked over or damaged when someone attempts to launch a boat. It's not unheard of. More importantly, as I stated in my statements, we have young children, and young children often are oblivious. And I have grandchildren. I have 3 of them that actually reside on the property. And I constantly tell them, you have to look for boats backing up down the ramp because they could be coming at any time. And when I say any time, there's no restrictions. Again, to Mr. Magnuson's point, the boat ramp is open literally 24 hours. So a person could drive down the nighttime when someone's walking down the street. But back to my point. There are children that are walking on that road, that ride their bikes on that road. And there's young children, they have tricycles and they're oblivious to what goes on. And the reason is that is just simply because they're young children. And that's what tends to be what happens when they're walking around. And a lot of them don't expect large boats to come backwards at them. And I've seen close calls. Have there been an accident? Not to my knowledge, but it can happen. And that is the biggest concern I have. Then one would say, okay, you don't have that capability or the skill. And a lot of people I've noticed do this. You can just tell they determined that I don't have the skill to back a boat backwards 350 feet to the water and pull it straight out without trespassing. So what they then do is they make a hard left on Lake Street. And I don't know if the exhibits have that available to you so you can see where Lake Street is, but it's just it is a road that is right above our property. And then they enter the property from Lake Street where there's a little clearance. It's not actually a road, but it goes into a private road. There's a dumpster in there. And they tow their boat through the property to get to the boat launch. And the reason they do that is because they don't have the skill set to drive 350 feet down to the waterway. So this is an easier way to do it. However, they're using private road when they do it. And as I said in my statement, I have personally observed this. This is not something that I'm just, making up. I've watched it. I've seen it almost every weekend. I see large vehicles, for example, pickup trucks, which is quite common, towing boats through the private roads and around through the parking lot, which is the only way to access the boat ramp that way. And again, it's, obviously inherently dangerous when that happens. So with that, I have a lot of concerns with operating the boat ramp and even open it even more widespread to the public. I would think would be just unreasonable. It just, in my mind, there's no sense to it. I can't even imagine really outside of some locals using it here and there. And that's kind of what we did. But we always tried to limit publication of the boat ramp just for the safety issues, and they're obvious. And I'd also support Mr. Magnuson's view, if the boat ramp is going to be continued to be open, that by all means, just common sense, let's restrict it to daylight hours. So we're not driving 350 feet backwards in the night. And the best way to do that, I think, would be to put a gate out in front of the boat ramp, because then it would discourage, in fact, probably eliminate daylight hour use. Those are some of my concerns, not all of my concerns. I'm happy to answer any questions. I've been up there for, like I said, for about 27 years, but I did offer commentary. I submitted it. I understand that you received it. And, my statements are there for you to review.
Thank you very much, Mr. McEachern. Anyone else?
I would like to speak if it's okay.
Absolutely. If you could please state and then spell your last name so that we make sure that we have it in the record.
My name is Christy Hoffpower. My last name is spelled Hoffpauer. I'm one of 11 cabin owners that have cabins directly across the water from the boat launch. Mine happens to be directly across. My family has owned this cabin since 1936, so we have been collectively going up there for 85 years. This is the only way that we can access our property. There is no road that goes to that side of the water. I did send my comments in email, but they're not posted on the website, so I wasn't sure if they got in or not. So that's why I'm speaking. I have my neighbors have also obviously expressed their concern that this is how we access our property and how we have accessed our property for many years. But I'd like to speak specifically to the recommendation of daylight only. Because this is the only way we access our property, I'm very concerned that there's many reasons why we might have emergencies or other reasons why we need to either access our vehicles or access our property, and it might not be as convenient as we would like it to be. So while I understand why that might seem like a very logical solution, I think it could cause a very dire emergency situation for our families of these 11 homeowners. I also wanted to mention that my property's been appraised multiple times recently by the state's hired appraiser. And that appraiser, the way they do appraisals obviously is to compare the property to similar properties on the lake. But because we have no road access, there's then a discount that reduces the value accordingly. In the appraisal, and I can give you a copy of it, the appraiser notes that because of the close proximity to vehicular access and marina space, they're limiting the discount on the property. I did try to object to this because it is not a public marina. We cannot keep our boats there. It does not make access that much easier, but the state and the appraiser maintained that the close vehicular access to be able to launch a boat was factored into the appraised value of our property. So having that closed, as has been recommended, would be very detrimental, not only for us to access our property, but for the valuation of our property as well. And that's the appraisal that was used to determine our lease payments and also to determine the price we had to pay the state for our property. I'm a little bit concerned about excluding the cement. I don't know what we're calling it here. We call it a dock, but everyone knows that this launch is very difficult to maneuver. And when you're launching a boat by yourself, not having anything there at all makes it even more difficult. Not impossible. I've done it. I've used an anchor. I've used all kinds of other things, but it is difficult. And I guess lastly, I would just say that I am capable of driving backwards and launching a boat. I've done it hundreds of times. I've never driven over anybody's property. I've never damaged anybody's property. So it is possible, particularly for people that are having to do this every single weekend. So those are my concerns.
Well, thank you very much, Ms. Hoffpower.
Thank you.
Anyone else?
I would like to speak. My name is Pamela McVeigh Richardson. I have submitted a letter to you, and I know that you said that you take that under advisement, so I won't reiterate much of that. But I have been a homeowner in Outlet Bay Owners Association since 1996, when my deceased husband and I bought our property. I've also been a board member for this association, and I feel like I have a very good understanding of the many years the issue has surrounded this boat launch. Actually, it's not a boat launch, it's a ramp. It's not a boat launch. I mean, it's difficult, like Christy pointed out, it is difficult to use. And I'm not disputing that the neighbors do not do a very good job backing down. It's the ones that are using it that come up to the campground. They're not familiar with the area. They're not familiar with the rules. And then I would also say that we don't close our boat launch. And I will also say that emergency use is available and used, and I have seen it used as that for EMTs to get people from the riverside over for emergency services. So that's not disputed. What's at dispute here is the citizens that are not familiar with our area. So I do not support Bonner County in receiving a permit. And I would just like to say, perhaps the county could look at an alternative. And there is an alternative site. If you will look 1/4 mile from Outlet Bay Owners Association on Lakeshore Road, there is a Forest Service campground. That is where many of the people that use our launch come from on a daily basis. And they're the ones not familiar. At Outlet Campground, there are restrooms, there are garbage service, there's turnaround, there's swimming services, boat area, and there's enough room there for turnaround. That's 1/4 mile away from this launch, and that is not in the middle of a residential environment. So like Alan, I support Alan. I've been there long enough to see all of these issues that have cropped up that people have mentioned. So I'm not used to talking in front of people, so forgive me. So in my opinion, I think the county would serve its fiduciary duties by investing in a full-size launch in conjunction with the Forest Service at Outlet Campground. In that location, a full-size launch would not fall short of providing for the citizens and public, as does the inadequate ramp at Outlet Bay site. An example of a full-size launch with services can be found approximately 8 miles from Outlet Bay Road on Lakeshore Road. So not only do we have the 1/4 mile campground with no launch currently, but 8 miles up the road, there is a Forest Service campground that does have a full launch. So, and that's in Kalispell Bay. So a similar full-size launch could be installed at Outlet Campground if it was explored, and communication and coordination between two entities would take place. Now, in Chrissy, I applaud you for your ability to back down, because there usually is not an issue with the area neighbors. I'm married now to a gentleman who lives across the river, and they used to all have mooring in our marina, and there was never an issue. But once because we're a private entity, we're not public. So therefore we didn't want to rent anymore. And so therefore we became just a private marina. That's when the problem arose with the neighbors, because they didn't have mooring. But there is mooring available on the lake. And there is access to launch your boats on the lake. So I don't think that's an issue. The emergency services, I have witnessed emergent EMTs backing down using our property, and that's just fine, to have access for people to come over by boat into an EMT facility. So I guess that's about all I'd like to say. Let's see. I was just kind of listening, I guess, but I just want to thank you for your time in reading the letter that I sent. So thank you, and listening to these comments.
Well, thank you very much, Ms. Richardson, and I did read your letter, and I appreciate your oral comments. So thank you. Anyone else? All right, hearing none. Mr. Amer, I'll hear from you now.
Good evening. Thank you, Mr. Hearing Officer. As has been noted several times today, hearing statement's already been issued and submitted. As is customary for these hearings, I will read a truncated version of the hearing statement. I will skip over the applicable legal provisions. But before I start, just like to notate that during Mr. Magnuson's testimony, he had called out that under 58-1306, that adverse effect upon adjacent properties takes the most important factor to be considered. And I believe that is in reference to 58-1306E, which states in recognition of continuing private property ownership of lands lying between natural or ordinary high water mark and the artificial high water mark, the board shall consider unreasonable adverse effect. So I believe that statement is in regards to what we call private submerged lands, which occurs on Lake Ponderay, where you have homeowners that actually own lake bed, but that would not be applicable to this hearing. So with that, just like to start off with the introduction there. My name is Mike Amer. I'm the Lands Resource Supervisor for the MICA Supervisory Area Office of Idaho Department of Lands, and I am the supervisor of the Navigable Water Program at IDL. My purpose in being here today is to provide you with information regarding IDL's assessment of application for encroachment permit L-97-S-1210, filed by Jeff Connolly with Bonner County Parks and Waterways. Bonner County Parks and Waterways is seeking an encroachment permit for an existing boat launch near Outlet Bay on Priest Lake. The Outlet Bay boat ramp is approximately 87 linear feet, 34 feet below the ordinary high water mark, and has a width of 15 feet. The concrete pier is approximately 32 feet below the ordinary high water mark and has a width of 8 feet. The water hydrant sits just below the ordinary high water mark on the south side of the ramp. 2 sections of the ramp were recently fixed to correct safety issues of the degrading ramp. So the ramp was not replaced, it was simply repaired. As far as the timeline goes,
Mr. Amer, before the timeline, what do you consider the water hydrant to be within IDAPA? How would you define it?
Mr. Hearing Officer, I would have to say that it would be considered a non-navigational encroachment. It doesn't serve any navigational purposes. And there isn't a specific call out type of encroachment in our code. And I would note that typically a non-navigational encroachment has a high threshold. It's got to be proven that it can provide a significant benefit to the public of Idaho through an environmental, economic, social purpose. And so as we heard today, it has a firefighting purpose. So I believe IDL would feel that that firefighting purpose serves the greater good of Idaho and would benefit the general public.
Thank you. Please proceed.
On November 3rd, 2021, IDL received an application to permit the existing boat launch at Outlet Bay. On November 9th, 2021, IDL sent adjacent neighbor notices to Outlet Bay Owners Association. Also on the 9th of November, IDL sent agency notices to local resource agencies such as Idaho Fish and Game, Idaho Department of Environmental Quality, Idaho Department of Transportation, and others. On November 10th of 2021, IDL emailed the Bonner County Daily Bee to advertise the application. And then on the 13th and 20th of November of 2021, Bonner County Daily Bee ran the advertisements in the newspaper publicizing the application. On November 29th, 2021, Outlet Bay Owners Association, through their attorney, John Magnuson, submitted a letter of objection to the application along with a $75 check and requested a public hearing. On the 16th of December, 2021, IDL's director issued a notice of appointment of hearing officer and hearing. And as we recently found out today, on December 30th, 2021 and January 6th of 2022, advertisements of the public hearing was ran in the Daily Bee. And as stated before, I will skip over several pages that discuss the applicable rules and definitions that were applied for reviewing this application. And skip to page 9, section 3, the memorandum order and decision on motions for summary judgment. On July 14th, 2021, District Court of the First Judicial District of the state of Idaho in and for the county of Bonner issued a memorandum order and decision on motions for summary judgment in regards to the boat ramp at Outlet Bay. Outlet Bay Owners Association was the plaintiff and Bonner County and IDL were the defendants. The matter came before the court on June 9th for a hearing on state of Idaho's motion for summary judgment filed on March 10th, 2021. Outlet Bay Owners Association motion for partial summary judgment filed on May 12th, 2021, and Bonner County's motion for summary judgment filed on May 12th, 2021. The July 14th, 2021 summary judgment decision set forth a list of undisputed facts, which were on pages 3 through 9, including that the boat ramp was originally constructed in approximately 1960 or 61 by the then owners of the Outlet Bay Resort. The district court further concluded that Bonner County received a deed in fee simple to River Drive, now Outlet Bay Road. As the owner in fee simple, the county owns the littoral rights associated with the road and boat ramp. IDL's analysis of the application's compliance with LPA and LPA rules. Based upon that summary judgment decision, Bonner County owns littoral rights for the land adjacent to the boat launch. Bonner County is seeking an encroachment permit for an existing boat launch. The application type would be considered a commercial navigational encroachment. According to measurements from Bonner County parcel webpage, Outlet Bay Road and the land the county received via a deed in fee simple is approximately 30 feet wide. Neither the LPA nor IDAPA have any square footage requirements for a boat launch or ramp. The proposed and existing boat ramp would be located outward into the lake 34 feet below the ordinary high water mark. The adjacent community dock to the north extends approximately 160 feet out into the lake. The adjacent dock to the south extends approximately 60 feet out into the lake. Therefore, the proposed and existing Bonner County boat launch would be located within the established line of navigability. One of the main issues raised in Outlet Bay Owners Association objection deals with the fact the proposed and existing boat ramp creates an adverse impact, presumably due to the fact that a 25-foot buffer is not being provided. However, the district court noted in a summary judgment decision as one of the undisputed facts that the boat ramp was originally created in approximately 1960 or 61, well before the Lake Protection Act. In addition, and significantly, Rule 1513E, the purpose of the 25-foot buffer is to protect adjacent neighbors' littoral rights. Littoral rights are only the rights of owners or lessees of land adjacent to navigable waters of the lake to maintain their adjacency to the lake and make use of their rights as riparian or littoral owners or lessees in building or using aids to navigation. In this case, there appears to be at least 185 feet between the end of the boat ramp and the end of Outlet Bay's community dock, or also 55 feet from the end of the ramp to the southwest corner of the nearest community dock. In addition, based on 2018 Bonner County aerial imagery, Outlet Bay's swimming area is on the north side of their community dock, while the boat ramp is located on the opposite or south side. So it's not near their swimming area. The proposed and existing boat ramp being applied for by Bonner County has been used by the public since 1950s, when members of the public launched canoes and small boats into Priest Lake from the end of River Drive, which is now Outlet Bay Road, and constructed as a commercial encroachment in the 60s, early 60s, by then owners of the Outlet Bay Resort. The boat launch has never been properly permitted, either to Bonner County or to the Outlet Bay Owners Association or its previous owners. The current application under review came about following the summary judgment decision and IDL's subsequent requirement that it be permitted. It appears to IDL that this application is simply to permit an existing boat ramp that has been in place since well before the Lake Protection Act, along with a concrete pier and water hydrant. Based upon a site inspection conducted by IDL on March 1st, 2021, it appears that the concrete pier and water hydrant are also existing and that no new construction would be taking place. As stated in Outlet.
Mr. Amer,
Yes, sir.
may I just interrupt you there? Do you know when the concrete pier and the hydrant were constructed?
I do not. I do not know that, Mr. Hearing Officer.
Okay, but it's seeming clear to me in reading the summary judgment decision that we know that the boat launch or the boat ramp was built prior to January 1, 1975, which is the date that's referenced in Idaho Code 58-1312. I'm trying to get a sense of a date that would be associated with the pier and the hydrant. And if we don't have a date, that's fine. I'm just wondering whether you know.
I do not know that, Mr. Hearing Officer, but I do know that based on our inspection, the concrete pier has been there for a while, as well as aerial imagery review. But I do not know if it was pre-1975 or not.
Okay, and another question that I had, Mr. Amer, on Idaho Code 58-1312 is the language is that the encroachment has not been modified since 1974. Has the department interpreted the word modified before, to your knowledge? And if so, how has the department viewed that word?
Mr. Hearing Officer, that is a tricky question. That is a challenging issue for us when we're dealing with pre-LPA encroachments and trying to determine whether they've been modified or not. Historically, I believe the department has taken modified to mean more or less changing size or configuration. To use an analogy with a grandfathered single-family dock that was built prior to 1975, if the landowner decided to redeck that dock with new decking material, that would just be considered maintenance and repair. That would not be considered a modification. Now, with that same analogy, if that homeowner took a straight dock and turned that into an L-shaped dock, we would consider that a modification because obviously the configuration has changed. I have not consulted with Ms. Kaufman about it, but I believe based on the inspection we did and the temporary permit that was issued, I believe the recent work on that boat ramp would be considered maintenance and repair as opposed to modification.
Okay, thank you. I appreciate that.
My pleasure. As stated in Outlet Bay Owners Association objection letter, IDL does not have any jurisdiction to regulate activities above the ordinary high water mark, such as parking or signage. Due to the fact that the boat ramp has been in place since the 1960s and used by the public since 1950s, along with the fact the summary judgment decision clearly spells out Bonner County's littoral rights for River Drive, IDL recommends the boat ramp and concrete pier application be approved. If approved, it is IDL's opinion that the encroachment permit should require terms and conditions in relation to parking, signage, and usage. It is IDL's recommendation that usage, such as hours and parking, mirror what historically has been allowed at the specific location, as that would match the current expectations of the public. Approval of the application would simply be placing the boat ramp and pier on an encroachment permit for the first time. IDL recommends approval for the concrete pier because having a pier or dock adjacent to a boat ramp is of utmost importance when launching or retrieving a boat, as well as because the concrete pier is existing and allowing its use would also mirror the public's expectations for that site. My last paragraph mentioned needing additional information on the hydrant to make a recommendation. It is still uncertain when the hydrant was originally installed or what its specific purpose was, but now we've determined that that purpose would be for firefighting. And we noted on our inspection in March 1st, 2021, that the hydrant was in place there. So it also would be part of the public's expectations at the site. And as you asked before, we would view that as a non-navigational encroachment that would serve a benefit to the public.
Okay, thank you, Mr. Amer. I'm looking at Mr. Magnuson's conditions, and I'll ask the same thing of Bonner County. So number one was time of use during daylight. That's something that would go on a sign. And what I read in your comment is, seems that you think that signage is within the department's jurisdiction. Is that correct?
No, Mr. Hearing Officer, the statement said that signage would occur above the ordinary high water mark. But we would recommend that it would be included as a term in the permit. And I realize that may be a confusing statement there saying it's outside our jurisdiction, but I do believe it would be for the greater good.
So that's my question is, you know, a sign that's above the ordinary high water mark. I mean, I suppose you could have a sign that's below the ordinary high water mark. But you're saying that, you know, it would be a term of the permit on number one, which is time and use, which of daylight hours, that you think is something that could be a term or a condition included in the permit. Is that correct?
I believe so, yes, Mr. Hearing Officer.
Okay. Number two on Mr. Magnuson's list was a gate. I'm assuming that gate to be effective would be above the ordinary high water mark. And that's something that would be, in your view, outside the department's jurisdiction, or do you think that's something that could be a term for this permit?
What I would state about the gate, Mr. Hearing Officer, is that if a gate was installed, it would definitely need to be above ordinary high water mark. Department of Lands has a history of not allowing gates and fences below the ordinary high water mark. something that's been highly discouraged over the years.
Okay. Number 3 on Mr. Magnuson's list was no parking in the street. Is that something that could also be a term in the permit?
I believe so, yes. And I would believe that the no parking in the street would probably be akin to a sign, a no parking sign.
Okay. Number 4 on Mr. Magnuson's list is back in only, and I've seen that in many of the comments. Is that also a term that could be included in the permit?
Yes.
Number 5 was signage, and we discussed signage. And do you feel that the permit could require signage to spell out the requirements? And again, going back to, you know, what your comment says about public expectation and how it's been used. And we have a boat ramp that does predate 1975.
Correct. I think I could sum up your line of questioning for my response with the statement that was in my hearing statement, that we'd like to continue the public's expectations for that site. There was a summary judgment that declared that Bonner County owned the littoral rights, but this had never been properly permitted. So we're simply just permitting something that's been in existence since the 50s and 60s. The public has used this, the public has benefited from this, but the department recognizes the proximity to the Outlet Bay Owners Association and the challenges that were raised with all the comments that we received. And so I believe the department feels that although the signage and the gate and the parking is stuff that is outside our jurisdiction, it seems to be, again, kind of for the greater good of both the Outlet Bay Owners Association and Bonner County and the general public. And Bonner County could speak to this, but I believe that the Outlet Bay boat launch was never advertised on any maps. I believe that might have been an agreement that was in place with Outlet Bay Owners Association, and the county was not advertised the location of that. And maybe that's something else that could be continued.
To not advertise the location.
Correct.
Okay.
But I do think that there needs to be some consult with Bonner County and the department and Outlet Bay on what these signage and usage would be, since it's outside of Department of Land's jurisdiction.
Well, and Mr. Hammer, I'm glad you brought that up, because in looking at this, you have a similar, by you, I mean the parties, including the department, you have a memorandum decision on summary judgment. I take it that was not appealed. Is that true?
That's correct.
Correct.
Okay, so that's the last word on that. I've heard a number of comments about being good neighbors and wanting to be good neighbors, and this one to me just seems like parties getting together and coming up with ideas on how to accomplish access. Seems like an awfully good thing. Just in reading the written comments, hearing the oral comments, how would you condition that? Could you condition that to require a sit down, a meeting of the minds to come up with reasonable rules and regulations on use of the boat ramp?
I'd have to consult with my legal counsel, Mr. Hearing Officer.
Well, and maybe I'll ask this of Bonner County as to whether or not the applicant would be willing to entertain something along those lines. And so, Mr. Cardona, unless Mr. Amer has anything further to add, I guess I would look to you to answer some of these questions, if you have answers or not, on how to put together, if this were approved, and again, we're not we haven't gotten to that point yet, but if this were approved, and you had mentioned earlier, Mr. Cardona, about, rules and regulations, what would you, as representative of the county, be able to do? And I'd like to hear some responses on that topic.
Definitely, sir. Thank you for the opportunity. I will start by saying that the negotiations and trying to find compromise is something that this wouldn't be the first time. I think that the department, when issuing the encroachment permit, has to be careful to not impose such conditions that will make this unmanageable for the county, as that will go against the main benefit, which is to continue the public access. The county definitely would not be going out of its way to make it more difficult for the local residents. Now, with that said, I think what the local residents should do is come and bring their issue to the county commissioners, like all the other residents do, in dealing with the property. What I would not want to see is a permit that includes a lot of language that goes beyond the authority or scope of IDL, and then is thrown on the parish to figure it out. Because I imagine such language might then come back to haunt us later on in a new stage of this saga.
We do have an interesting case here where you've got a pre-1975 encroachment, and the facts to me on that point are clear.
Yes.
You've got a summary judgment decision saying that the ramp of the launch was built in the early 1960s. That predates 1975. So we're dealing with a pre-Lake Protection Act question, which I think adds a nuance that is a little different than an ordinary. I'm going to look through IDAPA and a little easier maybe in some senses with check boxes and how do you process something. And so I do appreciate what you're saying. I have a list here from Mr. Magnuson. I went through this list with Mr. Amer, and I would like to go through this list with you.
Certainly.
So, on number one is time of use, which is, as Mr. Magnuson described, as daylight hours only. Is that something that Bonner County can live with?
The county can definitely live with daylight use, but we also take into consideration the extraordinary circumstances that will go beyond that use. There is also the issue of enforcement. The county would be posting signs for daylight use next to the boat access, like it does for all the other places. But that brings us to point number two, a gate. A gate will not be feasible for the county.
So let's go, before we go to
Yes,
point number two, which is the gate, let's talk about the signage. Would you be willing to install signage? I hear a lot about the intersection of Lake Street and Outlet Bay Road. Signage that's down near the boat ramp. When I read the comments, it's questionable for some of the people when I read it, that they're saying, well, people are already down, they've already driven in, not backing in, but driven in with their front bumper facing toward the lake. Would the county be agreeable to installing signage, somewhere more in that vicinity of the intersection of Lake Street and Outlet Bay Road?
Your Honor, I need a second to consult my client on that.
Please, thank you.
Your Honor, that has actually been already considered and is something the county is planning to do. With that said, there's a difference between things done for the community and the safety and things that are required as part of the encroachment permit. So just because the county is willing to do something like that, it is not a requirement of the permit. And if the residents of the area desire any additional signs or more signs, they should go through the normal procedure, which is talking with the county departments and putting it in front of the decision makers.
Okay, and I understand that, but in the scope and context of this, if the county is willing to install signage and were to agree to it within the scope of context of this particular action, that's my question.
For that corner, it has already been considered, so I believe the county will be willing to do that. Yes, Your Honor.
Okay. Talk to me about the gate then. We went to point number 2 when I interrupted you.
Yes, Your Honor, so putting a gate would be unfeasible. The county will have to have both the resources to install it and manage it and the associated liability. And there is no reason why the county will do that for this particular access when it doesn't do it for the remaining access points to the lake. I just do not see how that will aid to the greater benefit, which for us in this case is maintaining the access. And access, that's the only public free access that the county has control over on that side of the lake. And we would like it to continue available and without a gate. I also am not sure how IDL can make us put a gate on our own property, but I have not researched that question. Thank you.
Thank you. So then point 3, which is no parking on the street.
Give me 1 second to check on the status of the parking, Your Honor.
Thank you.
Your Honor, so looking at the right of way and the way it is currently being managed, it appears that much of the space where people are parking, while it's being maintained by the local property owners, is actually part of the easement to the public. So what the county could do is go back, and it has been surveyed before, that's how we can make that statement, and remark where the public right of ends, and then limit parking to the public right of way. The residents, of course, are welcome to call and inform us when somebody has abandoned a vehicle, when somebody's parking illegally. But that would be just in the regular course of dealing with the county, not as a special rights associated with this public right of way.
Okay, and so on the signage, would you be agreeable to saying no parking in the public right of way, which is the street?
I think so. 1 second, Your Honor. Your Honor, so
Clarification.
for clarification, the public right of way includes portions that are beyond the roadway. And we don't think we should be refusing all parking there because they would make it practically impossible. It maybe not quite that bad, but very difficult for somebody to come and use the public access.
So the public right of way extends quite a, when we were talking about the lawns and the different, planters and stuff, a lot of that is public right of way.
So I'm looking at, I'm looking at exhibit M6, which is a photo.
Yeah, we are too.
That is the one we are looking at, Your Honor. And
That one seems like a nice one to illustrate the question.
And then for the record, before who spoke was Commissioner Connolly.
Yeah, sorry about that.
Thank you, Commissioner.
Yeah. So
You're not proposing to park right down there along the, in front of these residents. It would be more above that, but I just want to recognize that, it is still public right of way, even though they mow it and make it their yard. It's still public right of way. And like I say, we've surveyed it multiple times, and I guess we'll have to do it again. It looks like the survey monuments have been tampered with, but.
So about how far on either side of the road does the public right of way go?
Well, it's a 30-foot right of way, so it's probably, it's probably not dead center, but it's really close to some of those homes. On the one side to the north, the large home, it is within a couple feet.
Okay, that helps. Thank you.
And just another little comment. This is Jeff Conley again, Commissioner. When we started talking with IDL about moving forward with the permit, one of the things that they said was the fire hydrant and the concrete structure there were and the launch, none were permitted. And they said that what we're going for is we'd like to see Bonner County permit all of them because they're outside of Outlet Bay Homeowners Association permits. So that's why we went forward that way. We claim no ownership to the water hydrant. It's there and it's definitely a benefit to the public. So we think it's important that it stays there. It's not ours. We didn't put it in, but we are willing to permit it just so it can be available to the community.
Thank you, Mr. Connolly. You don't happen to know when that was installed, do you?
I do not. I wish I did.
Okay, thank you. Point number 4, Mr. Cardona, was the back end only.
Can we assign to that? Are you okay with assign for back in?
And that's true. It's for back in from Lake Street and that's pretty normal. It's not that abnormal to have a large distance to back, and especially Priest Lake, there's limited access at Priest Lake, and it's important to me that we maintain the historic use of this boat launch.
On that historic use question, and Mr. Amer had mentioned this about historically this boat launch has not been on maps. Is that correct?
Yeah, and there's a reason for that. In another lawsuit with Bonner County and Outlet Bay Homeowners Association, it was agreed to.
Yeah.
And so not to bring more people, just leave it for the local use. And that's really what it is, mostly just the local use. People that are right in that area.
And the county is not looking to grow this access. The direction has been clear that we want to maintain the public access, not to make this a special new feature of Bonner County.
And if you observe, I'd say M10 is probably the most telling picture there. You'll see that what disrepair the launch is actually in. Below where we repaired it. And this is why we originally went in there. We didn't intend to go below high water mark. That was a miscommunication between our workers and our foremen. We only intended to fix a hazard on the above high water. And, but anyway, if you look at that, you can see what disrepair that is in. And we would probably like to just repair that so it's more usable and safer.
The Parks and Recreation was just noting that the back end use is not the historic use only. There's also people who bring smaller boats, canoes, kayaks. So those will not be back end only.
They pull in forward and unload and then park up above.
Yep.
Sure, a kayak off the top of the roof.
Right.
Yeah, rather than back out. Yeah, I follow you.
Yeah.
Anything else?
I'd say one more thing. I think it's important to recognize the use of the people, the 11 lots across the lake that have historically used this for years and years. I don't think they want to be caught in the middle of this fight, but I think it's important to recognize that this access is very, very important to them.
Well, that's a question that I'm wrestling with, and I've read the comments and then heard the oral comments from Ms. Huff-Power, and it's something I'm certainly thinking about. So thank you, Mr. Connolly, for emphasizing that point.
Yeah, and that is a really good point, Your Honor. Earlier, there were comments about other potential access points that the county could create. But at this time, the only public access the county controls unilaterally, once the encroachment permit is granted, of course, will be this access. So we want to be neighborly. We want to make sure that the signages work, but we also want to make clear that we're not creating a special outlet bay preferential treatment. You tell the county how to run the county. Other than that, that's all we have, Your Honor. I think IDL has presented our position very well. They understand what we're trying to do. And if this encroachment permit is granted, we will comply with the conditions to the maximum extent the law allows us to comply.
Thank you very much, Mr. Cardona. Okay, and with that, the time is just on my clock, it's 7:47 p.m. Pacific time. And hearing nothing else, I will close the hearing. I appreciate everybody's participation. I appreciate the thoughtful comments. And I will issue a written preliminary order, which will then be reviewed by the director, and you'll see a decision in 30 days. So thank you very much. And with that, Chris, let's go off the record.